In episode 9 of the Supreme Court Opinions Read podcast, I'll be reading the Supreme Court's opinion in Williams v. Reed. The case was decided February 21st, 2025. And as always, we begin with the syllabus. Petitioners are unemployed workers who contend that the Alabama Department of Labor unlawfully delayed processing of their state unemployment benefits claims. They sued the Alabama Secretary of Labor in state court under 42 U.S.C. Section 1983, raising due process and federal statutory arguments and seeking a court order requiring the department to process their claims more quickly. The Secretary moved to dismiss on several grounds, including that the state trial court lacked jurisdiction because the claimants had not satisfied the relevant statute's strict administrative exhaustion requirement. The state trial court granted the Secretary's motion and dismissed the complaint, leaving the claimants in a catch-22, unable to sue to obtain an order expediting the administrative process because they had not yet completed the process allegedly being delayed. The Alabama Supreme Court affirmed on failure to exhaust grounds, concluding that Section 1983 did not preempt the state's administrative exhaustion requirement. Held. Where a state court's application of a state exhaustion requirement in effect immunizes state officials from Section 1983 claims challenging delays in the administrative process, state courts may not deny those Section 1983 claims on failure to exhaust grounds. Part A. A state law that immunizes government conduct otherwise subject to suit under Section 1983 is preempted even where the federal civil rights litigation takes place in state court. Thus, in Howlett v. Rose, this court held that Section 1983 preempted a Florida rule extending the state's sovereign immunity from Section 1983 suits to municipalities, counties, and school districts because it in effect afforded immunity from certain Section 1983 claims. And in Haywood v. Drown, the court held that a New York statute designed to shield correction officers from damages claims by prisoners was preempted by Section 1983. Part B. Under Alabama's exhaustion requirement, state courts cannot review claims of unlawful delays under Section 1983 unless and until the claimants first complete the administrative process and receive a final decision on their claims. Such a requirement operates to immunize state officials from a narrow class of claims brought under Section 1983. Under this court's precedents, Alabama cannot apply such an immunity rule. Part C. According to the Secretary, the jurisdictional nature of Alabama's exhaustion provision distinguishes it from the state rules at issue in Haywood and Howlett, but this court's precedents have not treated the jurisdictional label of state rules as dispositive when state rules functionally immunize defendants from a class of Section 1983 claims in state court. In Haywood, for example, the court stated that the jurisdictional status of New York's rule did not insulate it from preemption. Next, the Secretary suggests that any delays in the state administrative process can be cured by claimants seeking a writ of mandamus from the state courts to compel the department to act more quickly. It is not evident, however, that mandamus is available to the claimants here. In any event, the Secretary's argument is simply another way of saying that the claimant must go through the state process before suing under Section 1983 to challenge any delays in that process. Just as Alabama may not force plaintiffs to complete the state administrative process before states may sue under Section 1983 to challenge allegedly unlawful delays, the state may not force plaintiffs to seek mandamus before bringing those claims. Justice Kavanaugh delivered the opinion of the court, in which Justices Roberts, Sotomayor, Kagan, and Jackson joined. Several unemployed workers in Alabama applied for unemployment benefits from the state. In their view, the Department of Labor has unlawfully delayed the processing of their benefits claims. So the claimants sued the Alabama Secretary of Labor in state court under 42 U.S.C. Section 1983, raising due process and federal statutory arguments and seeking a court order requiring the department to process their claims more quickly. The Alabama Supreme Court ruled that the claimants could not sue under Section 1983 to challenge delays in the administrative process until the claimants completed that process. But that ruling created a catch-22. Because the claimants cannot sue until they complete the administrative process, they can never sue under Section 1983 to obtain an order expediting the administrative process. This court's precedents do not permit states to immunize state officials from Section 1983 suits in this way. See Haywood v. Drown and Howlett v. Rose. On that narrow ground, we reverse. Part 1, Section A. The state of Alabama grants monetary benefits to unemployed claimants who meet certain eligibility requirements. To obtain unemployment benefits, a claimant must first apply to the Alabama Department of Labor in accordance with such general rules as the Secretary may prescribe. Footnote 1. During this litigation, Alabama changed the name of its Department of Labor to the Department of Workforce, and Greg Reed, Alabama's first Secretary of Workforce, was substituted as the respondent. Like the parties' briefing, we refer to the Secretary and the Department by their titles when this suit was filed. Carrying on. After receiving an application, the Department, through an examiner designated by the Secretary, must promptly make a determination on the claim. The Department must promptly notify the claimant of the determination, generally by mailing a notice to his or her last known address. The relevant statutory provisions do not define promptly. A claimant who wants to appeal an adverse determination must, within 7 days of the delivery of the notice or 15 days of the mailing of the notice, seek review by an appeals tribunal. The tribunal consists of a department employee who is appointed by the Secretary. The tribunal must hear and decide disputed claims and other due process cases related to benefits claims. And the tribunal must promptly hold a hearing. The tribunal must then decide the appeal within 30 days of the hearing. A claimant who loses before the appeals tribunal may seek discretionary review before the department's Board of Appeals, which is composed of 3 members appointed by the governor. A claimant must seek review within 15 days from the date when the appeals tribunal's decision was mailed to the claimant. If the Board of Appeals does not grant review within 10 days of the claimant's filing, then the decision of the appeals tribunal becomes final. After the Board of Appeals denies review, fails to grant review within the 10-day period, or grants review and issues an adverse decision, the claimant may then challenge the denial of benefits in Alabama state court, but not until then. The Alabama law setting forth these procedures includes a strict exhaustion requirement which provides, no circuit court shall permit an appeal from a decision allowing or disallowing a claim for benefits unless the decision sought to be reviewed is that of an appeals tribunal or of the Board of Appeals, and unless the person filing such appeal has exhausted his administrative remedies as provided by this chapter. That statutory procedure shall be exclusive. On its face, the state's exhaustion requirement prevents claimants from challenging adverse benefits determinations in state court, including in suits brought under Section 1983, until the Board of Appeals has completed or denied review. Section B. In this case, 21 Alabama claimants filed for unemployment benefits. They contend that the department, in various ways, has unlawfully delayed the processing of their benefits claims. For example, plaintiff Derek Bateman alleges that he attempted to appeal his claim to an appeals tribunal, but according to Bateman, the department never scheduled a hearing or otherwise acted on his appeal, even after he attempted to follow up by email and phone calls numerous times. The 21 claimants sued the Secretary of Labor in his official capacity in the Circuit Court of Montgomery County, Alabama. Invoking 42 U.S.C. Section 1983, they asserted, among other things, that the department's delays in processing their benefits claims violated the Due Process Clause of the 14th Amendment and the Social Security Act of 1935. The claimants did not ask the court to rule that they were entitled to unemployment benefits. Rather, they simply asked the court to order the department to promptly address their benefits claims. As relevant here, the claimants sought a court order requiring the department to 1. Issue an initial non-monetary decision within the next 10 days to every plaintiff who has not yet received a decision. 2. Provide within 10 days a hearing date for each of the plaintiffs who has requested a hearing. 3. Schedule such hearings for a date not later than 90 days after the request for the hearing. And 4. pay every approved claim within 2 days of the date of approval. The Secretary moved to dismiss the complaint on several grounds. The Secretary argued, among other things, that the state trial court lacked jurisdiction because the claimants had not satisfied the administrative exhaustion requirement in Alabama Code Section 25-4-95. The court granted the Secretary's motion and dismissed the complaint. The claimants appealed to the Alabama Supreme Court. That court affirmed on failure to exhaust grounds. The court concluded that under this court's precedents, Section 1983 did not preempt the state's administrative exhaustion requirement. Justice Cook dissented. He reasoned that under this court's Section 1983 precedents, the state could not bar a suit challenging the department's delays in making a determination on a benefits claim. This court granted certiorari. Part 2. The Secretary argues that Alabama's exhaustion requirement constitutes a neutral rule of judicial administration, and that the Alabama Supreme Court permissibly applied that statutory rule to bar the claimant's Section 1983 suit in state court. The claimants respond that Alabama may not preclude Section 1983 suits on failure to exhaust grounds when, as here, plaintiffs challenged the department's delays in processing their claims. Otherwise, they say, Alabama's rule would create a catch-22, preventing adjudication of, and in effect immunizing state officials from, this narrow category of Section 1983 claims about delays in the administrative process. Footnote 2. The claimants also contend more broadly that this court's Section 1983 precedents, especially Patsy v. Board of Regents of Florida and Felder v. Casey, categorically bar both federal and state courts from applying state administrative exhaustion requirements to Section 1983 claims. We need not address that broader argument. Carrying on. In the unusual circumstances presented here, where a state court's application of a state exhaustion requirement in effect immunizes state officials from Section 1983 claims challenging delays in the administrative process, state courts may not deny those Section 1983 claims on failure to exhaust grounds. Section A. This court has long held that a state law that immunizes government conduct otherwise subject to suit under Section 1983 is preempted even where the federal civil rights litigation takes place in state court. As the court has explained, states possess no authority to override Congress's decision to subject state officials to liability for violations of federal rights. That principle bars any state rule immunizing state officials from a particular species of federal claims, even if the immunity rule is cloaked in jurisdictional garb. In Howlett v. Rose, for example, the court analyzed a Florida rule extending the state's sovereign immunity from Section 1983 suits not only to the state and its arms, but also to municipalities, counties, and school districts that might otherwise be subject to suit under Section 1983. This court held that Section 1983 preempted Florida's rule because the rule in effect afforded immunity from certain Section 1983 claims. And in Haywood v. Drown, the court addressed a New York statute depriving state courts of jurisdiction over claims by prisoners seeking damages against state correctional officers. The court reiterated that states lack authority to nullify a federal right or cause of action they believe is inconsistent with their local policies. In violation of that principle, New York, in essence, had created an immunity defense for correctional officers when those officers were sued under Section 1983 in state court. The Haywood Court held that the unique scheme adopted by the state of New York, a law designed to shield a particular class of defendants, correctional officers, from a particular type of liability, damages, brought by a particular class of plaintiffs, prisoners, was preempted by Section 1983. Footnote 3. In Haywood, the court declined to address whether Congress may compel a state to offer a forum otherwise unavailable under state law to hear suits brought pursuant to Section 1983. This case similarly does not require us to address that underlying question. Alabama has made this inquiry unnecessary by creating courts of general jurisdiction that routinely sit to hear analogous Section 1983 actions. Carrying on. Section B. Here, the Alabama Supreme Court ruled that the state's exhaustion requirement applies to procedural challenges related to the administration of unemployment compensation benefits in addition to substantive challenges regarding the decision to award or not award those benefits. and it concluded that the universe of procedural challenges requiring exhaustion includes Section 1983 suits alleging that the department is unlawfully delaying the processing of benefits claims. Alabama's exhaustion requirement operates to immunize state officials from a narrow class of claims brought under Section 1983, namely, claims of unlawful delay in the administrative process. Under Alabama's exhaustion requirement, state courts cannot review claims of unlawful delays under Section 1983 unless and until the claimants first complete the administrative process and receive a final decision on their claims. In essence, Alabama has said that to challenge delays in the administrative process under Section 1983, you first have to exhaust the administrative process. Of course, that means that you can never challenge delays in the administrative process. That Catch-22 prevents the claimants here from obtaining a merits resolution of their Section 1983 claims in state court and in effect immunizes state officials from those kinds of Section 1983 suits for injunctive relief. Under this court's precedents, however, Alabama cannot maintain such an immunity rule. As this court's cases have repeatedly held, a state law that immunizes government conduct otherwise subject to suit under Section 1983 is preempted, even where the federal civil rights litigation takes place in state court. Footnote 4. Importantly, the court's holding today does not mean that premature procedural due process claims will necessarily prevail. As this court has stated, a procedural due process claim is not complete when the deprivation occurs. Rather, the claim is complete only when the state fails to provide due process. Therefore, as counsel for the claimants rightly acknowledged at oral argument, a plaintiff who asserts a due process claim without exhausting will usually lose because of the requirement that the challenged procedural deprivation must have already occurred, except in an unusual case where you're actually challenging the inability to exhaust. Here, the claimants allege that the state's delays in completing the administrative process violated their due process and statutory rights. We take no position on the merits of those claims. Carrying on. Section C. In response, the Secretary advances two primary points. First, the Secretary argues that the jurisdictional nature of Alabama's exhaustion provision sets it apart from the procedural rules that may be more readily preempted by Section 1983. In particular, according to the Secretary, the jurisdictional status of Alabama's exhaustion requirement distinguishes it from the state rules at issue in Haywood and Howlett. States retain substantial leeway to establish the contours of their judicial systems and are free to enforce neutral jurisdictional rules. The Secretary's argument fails, however, because this court's precedents have not treated the jurisdictional label of state rules as dispositive when state rules functionally immunize defendants from a class of Section 1983 claims in state court. In Haywood, for example, a New York law withdrew the state court's jurisdiction over a class of Section 1983 claims against correctional officers. The court stated that the jurisdictional status of New York's rule did not insulate the rule from preemption. As the court explained, New York's law operated as an immunity statute cloaked in jurisdictional garb. To treat the jurisdictional label as dispositive would allow the supremacy clause to be evaded. Second, the Secretary suggests that the claimants could seek a writ of mandamus from the state courts to compel the department to act more quickly. For that reason, the Secretary says that any delays in the state administrative process can be cured within the state judicial system. To begin with, it is not evident that mandamus is available to the claimants here. The Secretary cites a lone, decades-old case from an Alabama Intermediate Appellate Court suggesting in dicta that mandamus would be appropriate in a case where a state agency intentionally delayed its decision on a couple's application to become adoptive parents. If mandamus relief were available in these unemployment benefits cases, one would have expected the Alabama Supreme Court to say so in its opinion here. Yet the court did not say or suggest that mandamus relief would be available. In any event, the Secretary's argument based on the supposed availability of mandamus is simply another way of saying that the claimant must go through the process provided by the state before suing under Section 1983 to challenge delays in the state process. To be sure, the availability of mandamus relief in state court might be relevant to the merits of a due process or federal statutory claim challenging delays in the state process, But just as Alabama may not force plaintiffs to complete the state administrative process before plaintiffs may sue under Section 1983 to challenge allegedly unlawful delays, Alabama may not force plaintiffs to seek mandamus before bringing those Section 1983 claims. Otherwise, by the time the plaintiffs could sue for injunctive relief under Section 1983, their claims would be moot. For its part, the dissent largely discusses issues that we do not address in this opinion. In Part 2C2, when the dissent eventually turns to the merits of our legal analysis, the dissent argues that Haywood's reasoning about immunity rules applies only where a focus on statutory purpose reveals that a state rule reflects policy disagreement with federal law. We respectfully disagree with the dissent's reading of Haywood. That decision did not endorse a freewheeling inquiry into whether a state rule's purpose or policy, however assessed, is at odds with federal law. Rather, a state rule runs afoul of Haywood if it operates as an immunity statute cloaked in jurisdictional garb by wholly barring a particular species of Section 1983 suits in state court. The dissent also suggests that the claimants forfeited their argument based on Haywood and Howlett in the Alabama Supreme Court. In that court, however, the claimants clearly raised the argument that under Section 1983, the state could not apply an administrative exhaustion requirement to their claims challenging delays in the administrative process. The dissent further says that our opinion may have ripple effects, but as we have emphasized, our opinion today is narrow. It resolves this dispute, but is careful not to go beyond this court's existing precedents. The Alabama Supreme Court interpreted the state's administrative exhaustion requirement for unemployment benefits claims to, in effect, immunize the Alabama Secretary of Labor from Section 1983 due process suits alleging that the department has unlawfully delayed in processing benefits claims. By affording immunity from those claims, the Alabama ruling contravenes this court's Section 1983 precedents. We therefore reverse the judgment of the Alabama Supreme Court and remand the case for further proceedings not inconsistent with this opinion. It is so ordered. Justice Thomas, with whom Justice Alito, Justice Gorsuch, and Justice Barrett join as to Part 2, dissenting. Alabama law requires claimants seeking unemployment benefits to exhaust their administrative remedies before suing over those benefits in state court. Petitioners, the claimants here, failed to complete that process before they sued under Revised Statute Section 1979, 42 U.S.C. Section 1983. The Alabama Supreme Court accordingly held that it lacked jurisdiction over the suit. That holding was plainly permissible. As a matter of first principles, states have unfettered discretion over whether to provide a forum for Section 1983 claims in their courts, and Alabama's exhaustion rule does not transgress the limitations that our precedents have recognized. The court concludes otherwise by endorsing an as-applied theory of futility that is both forfeited and meritless, moving our jurisprudence even further off course. I respectfully dissent. Part 1. This case is straightforward under first principles. Our federal system gives states plenary authority to decide whether their local courts will have subject matter jurisdiction over federal causes of action. The Constitution allows states to hear federal claims in their courts, but it does not impose a duty on state courts to do so. Thus, once a state exercises its sovereign prerogative to deprive its courts of subject matter jurisdiction over a federal cause of action, it is the end of the matter as far as the Constitution is concerned. The only potential constraint that the Constitution places on a state's jurisdictional discretion is the possibility that a federal statute may preempt state law. The Supremacy Clause makes the Constitution and the laws of the United States which shall be made in pursuance thereof the supreme law of the land. Accordingly, federal law must prevail when Congress validly enacts a statute that expressly supersedes state law or when the state law conflicts with a federal statute. This preemption rule raises the difficult question whether Congress can require state courts to entertain a federal cause of action. We need not answer that question here because Section 1983 does not raise any preemption issue. By its text, the provision does not command states to provide a forum for Section 1983 plaintiffs. Instead, it merely addresses who may sue and be sued for violations of federal law. Nor does Alabama's exhaustion bar, which regulates state court litigation, create any implicit conflict with Section 1983. Plaintiffs who do not exhaust state remedies are always free to bring their claims in a federal forum. Preemption analysis requires nothing further. This court's precedents err to the extent they recognize a broader form of conflict preemption for state court procedural rules that are perceived to burden the exercise of the federal right in state court. This form of conflict preemption targets state law rules that constitute an obstacle to the goals embodied in federal law, but only federal law itself can support preemption under the Supremacy Clause. Extra-textual speculation about Congress's purposes cannot. Our precedents also err in establishing the requirement at issue here, that state jurisdictional rules be neutral even in the absence of a directly conflicting federal law. The Supremacy Clause does not of its own force constrain the state's authority to define the subject matter jurisdiction of their own courts. Rather, in making the Constitution and federal law supreme, it provides only a rule of decision that the state court must follow if it adjudicates the claim. I would therefore disregard our further limitation as demonstrably erroneous. Footnote 1. Petitioner's suit implicates other precedents that may not withstand scrutiny. I doubt that petitioners have a true due process interest in mere government benefits and entitlements. Tellingly, the court's original expansion of the Due Process Clause into this context came without meaningful legal analysis. The court simply highlighted the social importance of entitlements which had come to make up much of the existing wealth in this country, and which only the poor had been theretofore unable to effectively enforce. As Justice Black recognized at the time, it strains credulity as a textual matter to say that the government's promise of charity to an individual is property protected by the 14th Amendment. Moreover, further examination may be required as to whether Section 1983 can provide petitioners a cause of action in any event. Carrying on. Taken together, this case should begin and end with Alabama's plenary authority to decide which federal matters its state courts will have subject matter jurisdiction to hear. Alabama exercised that authority to create an exhaustion requirement, and we should respect its decision. Part 2. This court should affirm even under existing precedents. Alabama's exhaustion requirement does not run afoul of the limitations that this court has identified on a state's authority to restrict federal causes of action from proceeding in state court. Petitioners misread our precedents in arguing otherwise, and the majority's theory likewise cannot pass muster. Section A. Although this court has held that there are limits on a state's discretion in regulating state court jurisdiction over federal causes of action, our precedents emphasize that state authority predominates. The general rule, bottomed deeply in belief in the importance of state control of state judicial procedure, is that federal law takes the state courts as it finds them. Each state thus has great latitude to establish the structure and jurisdiction of its own courts. This latitude allows states to decide which federal claims their courts can hear. As relevant here, our precedents establish that states must exercise this jurisdictional latitude only through neutral rules that do not embody any policy disagreement with federal law. Based on this principle, we have identified two narrow exceptions to a state's ordinary discretion. First, a state may not refuse to hear a federal claim solely because it is brought under a federal law. Second, a state may not deprive its courts of jurisdiction over a disfavored federal claim even if it simultaneously denies jurisdiction to an identical state claim where doing so would undermine federal law. For good reason, no one suggests that the first exception applies. Alabama's exhaustion requirement by its terms does not discriminate against rights arising under federal laws. Instead, it imposes a generally applicable exhaustion process for the making of determinations with respect to claims for unemployment compensation benefits. State and federal claims regarding unemployment benefits are equally subject to this process, including as to procedural challenges like the one here. The second exception does not apply either. Alabama's exhaustion requirement is nothing like the statute in Haywood that this court viewed as disfavoring federal law. That statute deprived New York courts of jurisdiction over damages suits filed by prisoners against state correction officers based on the state's belief that they were by and large frivolous and vexatious. This court deemed New York's rule effectively an immunity statute cloaked in jurisdictional garb which protected correction officers from a subset of disfavored Section 1983 claims even as New York courts continued to hear most Section 1983 actions. According to the Haywood majority, that policy-driven denial could not be squared with the supremacy of Section 1983's countervailing policy. Alabama's decision to create an exhaustion requirement for all unemployment benefits-related claims does not embody any comparable policy judgment. Rather, this requirement, which has existed since 1939, is an ordinary jurisdictional rule reflecting the Alabama Department of Labor's comparative competence over the subject matter of unemployment benefits. The exhaustion process serves all the useful function that this court has recognized. It allows the agency with subject matter expertise to retain primary responsibility over the area, it avoids unnecessary litigation, and it creates a record in case judicial review is necessary. In short, Alabama's exhaustion requirement is a procedural step that promotes judicial efficiency, in contrast to the statute in Haywood, which created a de facto immunity, shielding a class of claims from judicial review. We have no authority to interfere with Alabama's choice. Petitioners try to evade Alabama's exhaustion requirement by arguing for a different exception. On their view, our decisions in Patsy v. Board of Regents of Florida and Felder established that states are categorically precluded from imposing exhaustion requirements in the Section 1983 context, but petitioners badly misread both decisions. Patsy addressed whether federal courts can impose an exhaustion requirement for Section 1983 cases in the absence of a congressional directive to do so. The court held that they cannot, reasoning that federal courts may create exhaustion requirements only where doing so is consistent with congressional intent, because Congress is vested with the power to prescribe the basic procedural scheme under which claims may be heard in federal courts. That analysis has no relevance to the question here, whether states have authority to establish the structure and jurisdiction of their own courts. Felder, too, is inapposite. That decision held that Section 1983 preempted a Wisconsin Notice of Claims statute that effectively altered the scope of Section 1983 liability on the merits. That is, the statute subjected state court plaintiffs to a dismissal with prejudice if they did not first submit their claims against the state or its officers to the government for an advance merits determination. Failure to exhaust under that statute operated as a state-created merits defense to Section 1983 liability. But the impermissibility of such a merits defense says nothing about a state's discretion to create true jurisdictional rules which speak only to the judiciary's power to proceed at all. Felder would remain inapposite even if it had involved a purportedly jurisdictional rule compelling dismissal without prejudice. In that event, the Wisconsin statute would simply have raised the problem that this court later confronted in Haywood, where the state singled out a disfavored category of claims for second-class treatment. The Notice of Claims statute in Felder existed to further the state's interest in minimizing liability and the expenses associated with it. And although Felder noted that the statute imposed an exhaustion requirement, it treated that fact as one of multiple interrelated factors that caused the Wisconsin statute to burden Section 1983 claimants. The exhaustion requirement was not an independently fatal problem, so Felder's language on exhaustion should not be overread. Section C. The majority rules for petitioners on narrower grounds, but its holding is equally unpersuasive. The majority does not dispute that, as a general matter, Alabama is entitled to apply its exhaustion requirement to Section 1983 claims. It instead holds that under Haywood, Alabama's discretion cannot extend to the specific claims here, which challenge delays in the exhaustion process itself. On the majority's view, maintaining the exhaustion requirement for such claims would mean that petitioners will never be able to advance to state court, leaving the state essentially immune from challenges to its exhaustion process. This theory of futility is both forfeited and meritless. Subsection 1. This court has almost unfailingly refused to consider any federal law challenge to a state court decision unless the federal claim was either addressed by or properly presented to the state court that rendered the decision we have been asked to review. In fact, the court's historical practice has generally been to treat this preservation requirement as jurisdictional, although our more recent cases have expressed uncertainty on this issue. In view of petitioners' preservation obligation, we should reject as forfeited their newfound theory of futility, which was neither presented nor addressed below. Until seeking certiorari, petitioners litigated this case as a facial challenge, arguing solely that Section 1983 categorically preempted states from applying exhaustion requirements in the Section 1983 context. The Alabama Supreme Court accordingly understood that this facial challenge was petitioners' only argument for federal preemption. Petitioners belatedly contended that they also raised a futility-based argument, but the briefing they cite merely addressed how the futility of waiting for exhaustion affected the proper timing for their facial challenge. Because petitioners raised only a facial challenge below, they cannot press an as-applied challenge here. Facial and as-applied claims are distinct and must be individually preserved. So, petitioners cannot now argue that Alabama's exhaustion requirement is impermissible in the specific circumstance where exhaustion would be futile. There is no reason to treat this case as the very rare exception in which petitioners' forfeiture might be overlooked. The majority, which ignores that petitioners needed to raise their as-applied objection specifically, certainly provides no justification. Instead, its analysis only highlights why we should not decide petitioners' as-applied challenge in the first instance. The majority's futility theory depends on the assumption that petitioners will never have their day in court if we leave Alabama's exhaustion requirement intact. But petitioners' failure to raise their as-applied claim below means we have no way of knowing whether this assumption is true. It may be the case that the exhaustion requirement here contains an implicit futility exception. Or it may be the case that petitioners may obtain mandamus relief as the dissent below suggested and the state underscored. As a federal court assessing petitioners' objection in the first instance, we have no way to assess the validity of these or any other mechanisms. The majority's attempts to disregard this uncertainty are unpersuasive. The majority concludes that the uncertainty should count against the state and expresses doubt about the availability of mandamus based on the Alabama Supreme Court's failure to address that form of relief. But that court had no reason to opine on the alternative pathways available to petitioners, given that petitioners failed to raise an as-applied challenge. We should not reward petitioners for their own mistake. Likewise, the majority's assertion that mandamus would be irrelevant even if it were available is puzzling. If petitioners can secure completion of the exhaustion process through mandamus, then by definition they will not be in a catch-22 that prevents them from obtaining a merits resolution of their Section 1983 claims in state court. Subsection 2. In any event, petitioners' as-applied challenge fails on the merits. Unlike the New York statute in Haywood, Alabama's exhaustion requirement is not an immunity statute cloaked in jurisdictional garb. Properly understood, Haywood directs our focus to the challenged statute's purpose. The court there viewed the New York statute as an immunity statute because it was designed to shield correction officers from damages claims brought by prisoners based on the belief that these claims tended to be frivolous and vexatious. In other words, states cannot implicitly reject the supremacy of federal law by basing a jurisdictional limitation, even one that also applies to state claims, on policy disagreement with federal law. A focus on statutory purpose makes clear that Alabama's exhaustion requirement raises no Haywood problem. There is no credible argument that Alabama adopted its exhaustion requirement in order to defeat challenges to the exhaustion process itself. Alabama created its exhaustion scheme in 1939, decades before the understanding that public benefits give rise to a due process interest emerged. And the Alabama exhaustion process is by all accounts an ordinary exhaustion requirement common among public benefits schemes, which in the mine run case serves to facilitate the adjudication of benefits determinations on the merits. There is no reason to think that Alabama intended to cause mischief in the rare context of a Section 1983 challenge to its procedures. At most, this case presents a circumstance in which Alabama's neutral jurisdictional rule has the effect of defeating a federal claim. But again, our precedents disallow a state's jurisdictional rule only if it is in fact not neutral, that is, if it is based on a policy disagreement and so is intended to shut the courthouse door to federal claims that it considers at odds with its local policy. The majority's contrary conclusion misunderstands Haywood. Ignoring that decision's purpose-focused language, the majority asserts that it disallows any state rule that operates as an immunity statute by wholly barring a particular species of Section 1983 suits in state court. But in context, that quoted language only reinforces the majority's error. Those lines in Haywood reiterate that what mattered there was New York's illicit purpose. A state may not deem a particular species of suits inappropriate for its trial courts, nor may a state effectively create an immunity statute based on the belief that certain claims are frivolous and vexatious. Nothing in Haywood suggests that a state rule could be impermissible just because it has the incidental effect of disallowing certain federal claims. The majority also does not grapple with the possible ripple effects of its reading of Haywood. It professes only that its opinion is narrow and does nothing more than resolve this dispute, but the majority's protestations do not make it so. A constraint based on incidental effects is notably more amorphous than our prior focus on statutory purpose. After all, to the extent the Supremacy Clause bars states from enacting nominally jurisdictional rules that register their dissent from federal policy, states may craft their laws with an eye toward avoiding conflict. But the same is not true for incidental effects. No statute can be perfectly drafted to anticipate every application that ultimately arises, so it is inevitable that exhaustion requirements will occasionally slow or defeat claims that we might think, as a policy matter, ought to go forward. That happenstance is not a reason for suspicion, just as we do not malign the many federal statutes with similarly categorical exhaustion requirements. Here, too, the court should not encroach on Alabama's latitude to establish the structure and jurisdiction of its own courts. Part 3. The court's decision is irreconcilable with both first principles and precedent. I respectfully dissent. And that does it for the reading of the opinions. I'll be honest, I have more thoughts on this than I thought I was going to have at the outset, and I am of a different opinion than I thought I was going to be while I was reading the majority. While reading the majority, I thought, yeah, surely they have this right. Like, in this very narrow context, the Alabama law pushes this specific set of Section 1983 claims out of state court. The court's precedents say you can't do that. So, you can't provide immunity, or in effect provide immunity to state actors from Section 1983 claims arising in state court. So, it seemed pretty straightforward to me. And so I was, kind of wondering, like, how do we get 4 justices dissenting here? Reading Justice Thomas's dissent was more persuasive than I thought it was going to be. Although, funnily enough, not really the part of the dissent that the other dissenters joined. The other dissenting justices joined as to part 2, which is where Thomas talks about the majority's opinion being inconsistent with existing precedent. That was not as convincing to me. Mostly because it's honestly really hard to tell at times what the Supreme Court's precedents actually stand for. So, arguing from precedent, I can see, why you would get this 5-4 split, but, or why it might be close or whatever. It depends on how you read the precedents. 5 of the justices read the precedents one way, 4 of them read it the other way. That's not the part that really interested me so much about the dissent. The part that interested me was part 1, where Thomas is arguing from first principles, and that was the part that none of the dissenters joined. And so this is one of the, I guess, sort of one of those instances of, Thomas and his lone dissents, which, I'll be honest, I quite like Thomas and his lone dissents. Even where I disagree with his lone dissents, I think it's fun that, you've got a Supreme Court justice consistently willing to sort of stick his neck out and be like the only one saying, no, actually, it's this way. All 8 of you are wrong. But yeah, the part 1 arguing from first principles was more persuasive to me. States are allowed to structure their own judiciaries. Nothing in the Constitution requires states to provide a forum for enforcing federal laws. and the only exception to that is if you've got a valid federal law enacted by Congress that does force states to have a forum for enforcing federal laws, which Section 1983, by its plain text, doesn't do. It says who is liable to who for what sorts of actions, but it doesn't say anything about where those claims have to be adjudicated, that they have to be adjudicated in state courts or federal courts or both. So nothing in the Constitution or Section 1983 says that states have to provide a forum for Section 1983 claims. So if states want to say we are divesting, or we are prohibiting our courts from hearing Section 1983 cases, they can do that. And then nothing in state law would prevent a person from bringing their Section 1983 suit in federal court. They might not want to. They might prefer state courts for some reason or another. But that doesn't mean that they are entitled by Section 1983 or the Constitution or anything else to litigate those cases in state court. I understand all of the other justices, dissenters included, are doing what the Supreme Court does, which is, to decide things and write opinions on much narrower bases than that. Not disturb existing precedent unnecessarily. Thomas has a habit of not caring about that and not caring about existing precedent. If it's wrong, it's wrong. To his mind, and I sort of I sympathize with that. I think stare decisis should be relied on much less. Again, if the decision's wrong, it's wrong. Obviously, exceptions to that, where you've got like an interpretation of a statute, there's a strong argument for stare decisis being stronger there, and reliance interests and all the rest. But generally speaking, I sympathize with Thomas there. Like, he says, yeah, whatever, you've got your precedent, I don't care. It's wrong, so get rid of it. Like, I will say the one thing that did sort of bug me about Thomas's dissent is the part in his footnote, where he doubts that Section 1983 creates a cause of action at all. And I intend to read the article that he's citing there to see, what, if any, merit that argument has. In my mind, the plain text of Section 1983 would seem to create a freestanding cause of action to me, but, he argues, and apparently this article that he cites argues, no, as originally understood, it didn't. Not really central to the opinions, why it was in a footnote, but that was one part that kind of bugged me a little bit, that I'm not sure I'll find myself agreeing on. But pretty much all the first principles stuff, yeah, I have to agree. Alabama can have its exhaustion requirement, and if that throws certain classes of Section 1983 claims out of state court, then that's what it does. Alabama's entitled to do that on first principles. Now, you've got Supreme Court precedent to the contrary, but that precedent's wrong. The Supreme Court, in my opinion, in Thomas's opinion, it seems as well, probably shouldn't be sustaining wrong precedent just because it's harder, at least in the short term, to undo it. That's how you get like these arguments that like, oh, this precedent's been around forever, how could you possibly overturn it? It's like, yeah, that's because the Supreme Court has, let it stick around forever because it just doesn't like to overturn wrong decisions. I don't know. I know, people both much, much more knowledgeable and, in my opinion, less knowledgeable have very different opinions about stare decisis and the strength that it should have in the Supreme Court's opinions and whatnot than I do. But I don't know. I can't shake the intuition that wrong is wrong, and if the Supreme Court realizes it's wrong, it probably, if it can help it, shouldn't let itself keep being wrong. So, all that said, I think Justice Thomas is right on first principles. Maybe he's right, maybe he's wrong on the precedent. I'm not sure. And where things are clear from first principles, I am not all that interested in whether he's right or wrong on the precedent, for reasons I've already rambled on about. One final thing that I wanted to mention that I also liked about Thomas's dissent and that I think he's right about is that the Supremacy Clause of the Constitution does not prohibit states from passing state laws that show a sort of disagreement or something to that effect with Congress's policy judgments. What the Supremacy Clause does is makes the Constitution and laws passed in pursuance thereof, by Congress, of course, the supreme law of the land. States can't violate them. States can't nullify them, and it's not the policy judgments of Congress that are the supreme law of the land. It is laws passed by Congress in pursuance of the Constitution that are the supreme law of the land. And the laws are, laws are just text ratified by legislatures, right? That's what laws are. They are not these sort of extra textual factors like, well, what did Congress intend by the law or intend to do with the law? What was their policy goals? What was their policy judgments? That is not the supreme law of the land. The laws passed by Congress are the supreme law of the land, the legal text, the statutes. And a state law might be in conflict with all the extra textual stuff, the policy judgments and whatnot. But if it doesn't come in conflict with the text that was actually passed by Congress in order to, affect that policy judgment, then the Supremacy Clause doesn't have anything to say about that. It's just the state can voice disagreement with Congress's policy judgments. And this is sort of a, I guess, textualist perspective. And some of the justices on the court are not perhaps as textualist as some of the justices in the minority or in the dissent, but I think that is the correct view of the law. And if Congress sees states passing policies, passing laws that it doesn't like, and that it can validly preempt, then it can preempt them. But if it doesn't do that, then states are free to make their own laws, even when they conflict with what Congress wants. If Congress wants states to do something or to not do something, it has to make laws about it. It can't, it has to pass new statutes about it. It can't say, well, but what we wanted you to do, or what we wanted this law to say, well, it's not what the law says, though, so fix it, right? But I think that's about all I have to say on this case, this decision. So if I may ask you, my friends on the other side of the screen, please like, share, comment, follow the podcast wherever you follow podcasts, and if you'd like to support the podcast, you can do so on Patreon. The main content of the show will, of course, always remain free, but Patreon members have access to episodes early and bonus or exclusive content, and they can request specific content, including other than reading Supreme Court opinions. With that, tune in for the next episode where we will not be continuing our trek through the Supreme Court's 2024 term. We will be moving on to the first opinions in the 2025 term. Till then.